Well, now that we answered already the first two very critical questions that are on everyone's minds, number one, could Wendi Adelson be indicted for the murder of Dan Markel? Now that we already have Charlie locked up, we have Donna arrested, can Wendi be next? And the answer was yes, even though she was granted use and derivative use immunity, if the prosecution has independent, legitimate evidence that she can use to convict Wendi, that is still possible. So that was number one. We also explained the whole background and understanding of use and derivative use immunity in previous videos. Go check that out if you haven't yet. It's very educational. It really gives you the entire background of the granting of immunity and why it's necessary and why it's important. So that was the bottom line of that was that she could be charged with murder. Number two was, well, if she committed perjury on the stand, does that going to strip her of her grants of immunity? And the answer to that was no, it's not going to strip her of her immunity, but she will be opening up herself to charges of perjury. She could be charged with counts of perjury. Now, what type of penalty could she be facing? What type of punishment could she be facing if she is convicted of perjury? So I've heard some different things over the past few days: 5 years, 10 years, 15 years, 30 years. Well, the answer is that since this was a capital felony trial, and if we prove that she did commit perjury, then she'll be facing a maximum of 15 years per occurrence. So every time that she committed the perjury, that would be another 15 years maximum. It doesn't mean that the judge, if she's convicted, is going to throw her away for 15 years each time. You know, that would be a question by the sentencing phase, but what she is facing at a maximum is 15 years per perjury committed. So let's jump into two arguments, pieces of evidence that will show that Wendi was committing perjury on the stand. We'll discuss the arguments about it, and again, like I always say, I'm not taking sides. I'm just going to bring you the analysis that both attorneys would have to analyze, how they would analyze these arguments. And also what I want to do is I want to take a dive into what perjury is and actually talk about the elements that you have to prove, and not just talk about perjury like, yeah, it's just lying under oath. It's not that simple. It's not that simple. So we're going to break down actually using the statute, using the case law in Florida to explain to you what is necessary in order to achieve a conviction on perjury. So, but first, let's show the clips. So the first clip we're going to show is the contradictions between Jeffrey Lacasse and Wendi Adelson about whether any serious conversation happened between Wendi and Jeffrey about whether Charlie actually was serious about hiring a hitman. Take a look.
She asked to speak to me confidentially in a very serious tone of voice, told me that Charlie had investigated all possible options to take care of the problem of Danny Markel, including hiring a hitman, which would cost about $15,000. And I later revised that and thought maybe it was $50,000, but the dollar amount was the only thing in question. She definitely said that Charles Adelson had looked into hiring a hitman to kill Danny Markel.
Did you say that Charlie, your brother, this defendant, had explored all options to resolve the problem, including hiring a hitman, and it would cost either $15,000 or $50,000?
No.
And did you have a conversation with Jeffrey Lacasse at your residence that night where you said you wanted to share something in confidence with him?
No.
Okay, so before we analyze that one, we're going to just show you the second clip that is also a fan favorite. This is one also a lot of people are talking about. So this has to do with where Wendi went. Did she pass by the crime scene the morning that Dan was killed? Take a look.
Did you go to the crime scene or very near the crime scene on your way from your residence to, I guess, to lunch or to wherever you were going next?
No, I did not.
So you never turned on Trescott Drive that day?
I went to turn on Trescott Drive, but I saw that it had been blocked off by some tape, and so I just kept driving on Centerville.
Okay, and when you had to turn around at the tape, right, to go back out?
I think I tried to turn right, and it couldn't turn, so I would have made like the kind of turn, like a K-turn, and kept going.
Was there a roadblock there with?
There was tape.
Yeah, and an officer was there?
I didn't see an officer, but I did see a car.
A law enforcement marked vehicle? Okay, did you have any contact with the officer?
No.
Okay. Did you do anything after that to try to find out what was going on down that roadway?
No, I just assumed it was weather or maybe a tree fell.
if you were just passing by Trescott Road on Centerville Road, would you have been able to observe the crime scene tape?
From Centerville Road?
Yes, sir.
No.
Why not?
There's a considerable distance between there, and it also kind of curves around.
Now here, it gets actually a little more interesting, because here she claimed that as soon as she got to Trescott, she was on Centerville, and as soon as she got to Trescott, she tried to turn in, but it was right away blocked off, and therefore she had to do this K-turn. According to Officer, was it Bill Brennan, he testified that no, the blockade was much further down Trescott, and you actually had to turn around, and you couldn't even see the blockade from Centerville. So that was clearly a contradiction in testimony. And also, she said that she had no idea why it was blocked off. She assumed that it would have to do with some sort of weather, maybe a tree fell. Well, that could be easy. Take a look at the weather record, see if there's any hurricanes or any thunderstorms that pass through the area, which would, lend Wendi to believe that maybe a tree fell down. If it was just sunny Florida for a week straight, why would you think any trees fell down in that area? But okay, maybe she can make an argument that, even if there's no weather reason, maybe some tree fell down anyway because it was getting old, or maybe there was some accident there. I don't know. Some other argument that she can make about whether she thought that it had something else to do, something to do with a tree and not Dan Markel's murder. So that was that. And then the officer testified that no, if you would have done the K-turn, and he said that basically she did the K-turn, he recognized her car, she did the K-turn right a few houses away from Dan Markel's, you would certainly be able to tell where all the action is, what's going on, and that should have given her pause for what's going on here if she was really taken by surprise. So that was his testimony versus her testimony. So we've got these two instances of perjury. This certainly can be an argument for perjury that Wendi committed on the stand in these two instances. Now, if there are other instances that you want me to analyze, please leave those in the comments and we'll see if I can get to them. But these are the two fan favorites, so we'll discuss these. But first, I want to understand and explain to you, what does it mean, perjury? What is perjury? How do you commit perjury in Florida? And what type of nuances are there? So looking at the statute, and this is the statute, the Florida statute 837.02. So taking a look at this statute, what's very interesting is that there's three subsections, and there's subsection 1, subsection 2, subsection 3. So let's take each one by itself, and you will already notice as we're reading subsection 1, and then we're going to go into subsection 2, what would seem to be what's glaringly different between subsection 1 and subsection 2. Okay, so let's go with 1. 1. Except as provided in subsection 2, which is the next subsection, whoever makes a false statement, so that's the first element, it has to be a false statement, which he or she does not believe to be true. So it's not enough that the person makes a false statement, but you have to know that it's not true. You can't believe that it's true. So that gets a little bit more difficult to prove. How did I not know that this statement was true? So that gets a little bit more into the intent of the person making the statement. That might be a little more difficult to prove, but still not crazy, especially if it's very clear what you were saying, and if you're saying is completely opposite to what you were doing, then that's very clear that you could not have believed that what you were saying is true. Okay, next, under oath in an official proceeding. We're talking about an official proceeding. This is certainly an official proceeding. Certainly she was under oath, so that one's certainly is satisfied. In regard to any material matter. If the statement is in regard to any material matter, which we're going to explain a little bit more later on, but just hold that in your thought for right now. It has to be with regard to a material matter. So if you did that, then you commit a felony of the third degree punishable as provided in subsection 775.082, which is essentially 5 years. Now this is just regular perjury. That brings us to subsection 2. Again, whoever makes a false statement, which he or she does not believe to be true, under oath, in an official proceeding that relates to the prosecution of a capital felony, commits a felony of the second degree. So if it has to do with the prosecution of a capital felony, then you've committed a felony of the second degree, punishable as provided in section 775.082, which is 15 years. Okay, now what is very glaringly missing in subsection 2, which was found in subsection 1. And everyone already, all my intelligent viewers have already noticed it. And that is that it doesn't say in subsection 2 that it has to be in regard to any material matter, which would seem to suggest that if you are testifying in a capital felony, in the prosecution of a capital felony, and you say anything that is a false statement, which you do not believe to be true, it's under oath, it's an official proceeding, then you are done. It doesn't have to be about a material matter. That's what it would seem to be from just the plain language of the statute. So that's the basic understanding. But here's where the problem gets to. Let's go to subsection 3. Subsection 3. Knowledge of the materiality of the statement is not an element of the crime of perjury under subsection 1 or subsection 2. So whether the person making the statement has knowledge that this statement is actually material to the case has nothing to do with it. So it doesn't matter what you know or what you don't know. If you're the one testifying and you're the one lying and you think that you're lying about something that's not important to the case, but it happens to be very important to the case, you cannot claim, well, I didn't know that it was important or not. That you cannot do. Your knowledge of whether this is material or not has nothing to do with it. But what's interesting is that in subsection 3 it says that your knowledge of the materiality of the statement is not an element of the crime of perjury under subsection 1 or subsection 2. Now hold on a minute. What do you mean subsection 2? Subsection 2 doesn't say a word about the requirement that the statement be with regard to any material matter. So now you're starting to see why lawyers can be driven crazy by these type of statutes. Because in subsection 2 it doesn't say a word about that has to be material. And subsection 3 infers, you can infer from subsection 3, that materiality is a requirement, but knowledge is not a requirement. Now, it seems to me from the case law also that materiality, meaning whether what you're talking about, whether you're lying about, is a material matter, does apply to subsection 2, which would mean that the only time that you can charge Wendi Adelson and convict Wendi Adelson of perjury is if it's with regard to a material matter. Okay? So, what is a material matter? How do you qualify for a material matter? That's the question. Well, I pulled this from a case. This is a Florida case. And this is what the case law says. In order for testimony to be material, it must have some weight and reference to the determination of an issue which is before the court for judicial determination. So it has to be in reference. It has to give some weight, or it has to be with regard and reference to the determination of an issue which is in front of this court. So what's the determination? What are we determining in each of these cases that Wendi testified in? It's not about her own case. It's not about something that would make a difference if she was on trial. The question is if what she's lying about material to the case in which she is testifying about. Or does it give it some weight? Now what does that mean? Does it give it some weight? So that would mean the following. Let's say you have an expert on the stand, and the expert lies about his credentials. He gets up and he lies. He says, for example, I went to Harvard Law. And he talks about all the different things that he's done and things that he's published, and he lied. He never went to Harvard Law. Now, it's possible that the jury gave his evidence, gave his testimony much more weight because of his credentials, because he went to Harvard Law. So even though it seems, oh, what does this have to do with the ultimate question and decision in this case? I'm just talking about my own personal credentials. Well, if the jury could have given your testimony more weight because of it, so then that is going to be considered material. And the case law continues. It is not essential that the false testimony bear directly on the main issue. It is sufficient if the false testimony is collaterally or corroboratively material to the ultimate material fact to be established. The degree of materiality is not of any important consequence. So, as long as it has something to that you can connect, if it's collaterally related to an ultimate material fact, that would still be considered a material matter. So it's very broad. It's not as restrictive as when you first read it. When you first read material, it has to be really material about what you testified about. No, not necessarily. If the jury would have looked at anything differently because of what you said, there can be an argument that that's already considered material. Now, let's use this analysis and let's plug it into the two scenarios which we spoke about, these two clips that we're speaking about in this video. The Jeffrey Lacasse versus Wendi Adelson, the contradiction about whether this conversation actually happened. Again, Jeffrey testified that Wendi told him that Charlie looked into all options, she was serious about it, and even looking into the option of hiring a hitman. Now, is that material? 100%. If Wendi is there telling Jeffrey that Charlie actually looked into hiring a hitman and he was serious about it, well, of course, that's the whole argument of that case is that he was only joking, he makes bad jokes, Charlie makes bad jokes, and none of this was ever serious, and he was really just extorted, right? But if you actually have testimony, you actually have where she actually told Jeffrey that Charlie was serious about it, well then that's for sure material. So there's no question at all that that's material. But the challenge with that is that what other evidence do you have to show that Wendi actually committed perjury? All you have really is she said, he said. He's saying that the conversation happened. She's saying the conversation did not happen. How else, what other evidence can we bring in? What other evidence can the prosecution bring in that she committed perjury? She's going to say that no, that conversation never happened, and Jeffrey's the one that's committing perjury. And Jeffrey's going to say, no, you're the one that's committing perjury. I'm the one who's saying the truth. And if that's all the jury has to determine whether she committed perjury or not, there can be a strong argument that it's not enough to get you beyond a reasonable doubt. So that's the problem with that first piece of perjury, that Wendi said that this conversation never happened, and Jeffrey saying that it does happen. Okay, that's problem number one. That's the problem with that one. What about the second scenario? Now the second one was where the officer said that she drove down all the way, did the K-turn, and went back, right? And she's saying, no, she just turned a little bit into Trescott from Centerville and was already blocked off all the way at the edge from Trescott to Centerville, and she immediately had to do a K-turn, right? Well, here you could have some other evidence. You can have some other police officers saying that, no, we didn't block all the street all the way up to Centerville. The street was only blocked off a few houses away from Dan Markel. And they can also testify that there's no way that you can even know that the street was blocked off unless you drive all the way down Trescott. So there you can have some other evidence. It's not just this officer, Bill Brennan, against Wendi. There can be some other significant evidence against Wendi about whether she actually went down Trescott or she just did a K-turn where Trescott meets Centerville. So there already you can have perhaps a stronger case for the perjury. But with that scenario, what you're going to run into in that scenario is, well, is that a material fact? Is that material to the decision of whether Charlie was the one who committed this murder, or when he conspired to commit this murder, or he solicited somebody to commit this murder? Does the fact that she went down that street, does that connect enough to the ultimate decision of that Charlie was involved with this murder, with the conspiracy to commit this murder, or not? And here's where you can make stronger the other argument. You can make perhaps the argument that no, that's not material to the case. Whether she did that or not, that just has to do with her own involvement in the crime, her own knowledge of the crime. Does that have anything to do, does that have any way of implicating Charlie's conspiracy to commit it? Now, you could, of course, make the argument, yeah, tangentially does, because if Charlie told her about it and then she knew about it and that's why she went there to check it out, so you could connect the dots. But at least an argument could be made that this is not material enough to be considered a conviction for perjury. That's why this gets a little interesting. Now, who decides whether an issue is material or not? Who gets to decide that question? Is that a question that's decided by the jury, or is that a question that's decided by the judge? Now here is where the general rule of thumb is that a judge decides the questions of law and the jury decides the questions of fact. So for example, here's the question. The question of fact is, did Charlie actually conspire and solicit this murder, or was this a double extortion? It's a question of fact. What happened? Was he extorted, or did he actually conspire to commit this murder? That's a question of fact. That's a question that was given to the jury. But all the questions of law, objections, questions of emotions, things that have to do with the law, that's in the judge's territory. The judge makes those determinations. So what about when it comes to something, whether something is a material for perjury? Is that a jury question, or is it a judge question? Is it a question of law, or is it a question of fact? Now, the statute in Florida says pretty clearly, if you take a look, this is the statute 837.011. And you can hear already why there can be arguments both ways. But the statute, and by the way, there's some extensive case law about this specific issue, whether something's material, whether this is material to the case, is a question for the jury or not. But the statute says clearly what it is, and I'm going to read it for you. This is again chapter 837.011, subsection 3. These are definitions. So definitions: material matter means any subject, regardless of its admissibility under the rules of evidence, which could affect the course or outcome of the proceeding. That's how the statute defines material matter. Any subject which could affect the course or outcome of the proceeding. Whether a matter is material is, in a given factual situation, is a question of law. It's a question of law. So this is a question that the judge is going to determine. So if this is, and which I think, by the way, could be the right call in this situation, because it gets complicated, and it may be a little bit difficult for the jury to actually make a determination without all the knowledge of materiality. So but what's clear from the statute is that this is a question of law, and the judge is going to have to make the determination. So if charges are brought against Wendi for perjury in this case, and from her testimony, this issue will be guaranteed will be brought up, and the judge is going to have to make a determination about each count of perjury, whether it's considered material. Once he or she considers it material, then it will get to the jury to the determination of the other elements that we went through already in the beginning of the video. So that is that. That is how we understand the perjury. That's how we understand what's going on with Wendi. We will see what happens if they eventually do bring these perjury charges, but I think that it was important just to go through it and understand the elements, understand the case law behind it, and that is it for now. Please, if you haven't yet, subscribe, like the video so we can continue bringing this analysis to you. See you next time.